Okay, boys and goyim, this is Vincent Bird of the 11th Hour Messenger bringing you part two. I'm trying this new camera rather than my camera on the computer, and if I seem to bump or touch anything, it wants to click off. So this is kind of disjointed. I didn't realize that this part that I'm going to repeat here had been cut out. So I'm going to give it a go and we'll try again. This section I'm going to deal with lawyers and lawyering. First of all, you must understand that the laws Congress passes, that the law enforcement makes arrests under, and that the prosecutors prosecute and the judges sentence under, the guilty, are all designed and processed by lawyers. Remember, more than 2,500, excuse me, remember that there are more than 25 million laws on the books and 10 million arrests each and every year. The priesthood of lawyers performs before hallowed symbols. The elevated high priest judges, platform number one, the flag, the judge in the robe of the high priest, the gavel, the water pitcher, the reporters recording the proceedings, and the clerks making the notations in the calendars and the computers. They chant in a dead language, Latin from time to time, and indeed have a language unto themselves called legalese. It is virtually impossible for John Q. Citizen to navigate that process without the aid of an attorney. Whoever is the most persuasive in the courtroom is the winner. Truth be damned, justice be damned, innocence and guilt be damned. Result is the conclusion of a lawyer's work at the end of the trial on the client's behalf. The result may be a dismissal, an acquittal, or a conviction by plea or jury verdict. It is all the same to the lawyer. It's just another result. If you understand nothing, as you sort through my information today, understand these facts. And this is probably the most important lesson you're ever going to learn about the judicial criminal injustice system in the United States of America. The lawyer's foremost obligation is to the United States government, to which he owes his livelihood, to practice law. The lawyer's second obligation is to the court itself, where he regularly plies his trade on the behest of the court. And third and far last, way down the list, the lawyer's final obligation is to you, the defendant, who falls short of his first two obligations to the government and to the court. Your lawyer is interested in defending you to the extent that you are willing to pay. He will extract his fees before he does one iota of work for you on your behalf. You can mitigate these fees sometimes and be able to negotiate some of those fees sometimes, depending on your desperate condition. But you generally end up going to a lawyer fairly desperate. You've either been arrested or indicted. The family member has made the phone call to the lawyer because you have no access to spend that much time trying to find a lawyer, or you'll end up with a public defender, and we like to call them public pretenders. And I'll touch on that in a little bit. Your lawyer can and will charge you by the minute to do any kind of research using his associates, clerks, and paralegals and his investigators. I call that the ka-ching factor. Ka-ching, ka-ching. The dollars keep rolling. Every phone call by you to he, or he to he, by he, every letter generated that must be read, every trip to and from visiting you, every conversation you have or he has with you, your family, your associates, a witness, or a person of interest, every motion brief, consult subpoena, memo note, document reviewed, character references solicited, and more will result in an itemized fee for that service. If your lawyer is reading, thinking, talking, and traveling, he will bill you for those services. Court appearances and waiting for those court appearances for your case to be called to the docket are always billed at higher rates. Often he will not even look at your case or folder until the day he comes to see you or you go into his office to discuss your case. Even the lawyer that you may eventually hire may not know anything about the law under which you have been charged. You will be paying him to do the research and shepherding the law to mount a defense before he can even begin to help you. Shepherding is the method lawyers use to work through the maze of rulings, precedences, and arguments used in like cases since the legal system began in the United States of America. These routings are spelled out in a major document called Shepherding. It's a legal book. Okay, you should be very specific when you ask your lawyer about your charges and listen carefully to his response. His ability to aggressively represent you is paramount to a dismissal, minimal sentence, or other consideration which will both save you money and potential time in prison. In essence, the law can mean anything that the prosecutor and the court wants it to mean, always in their favor. The courts do not want you playing in their game and have implemented every sort of subterfuge and stumbling block to deter you from defending yourself. You have probably heard that only a fool will defend himself in a court of law. And yes, in fact, most lawyers won't even defend themselves if they are a defendant. However, you still can do much for yourself before you enlist the aid of a lawyer. You can do things like go through your arraignment, make your initial pleas, make motions for dismissal, and even for discovery. That will save you a little bit of money on the front end. Unfortunately, most people arrested do not have the time, the resources, or wherewithal to ferret out the necessary information to help you in your own case. The internet is extremely helpful in today's world, but most state and federal facilities will not give you access to a computer system that has outside access. Most inmates, while they're detained, have a real serious problem, even though there is a limited law library in most facilities. There is money in complexity, and the government's criminal justice system is about as complex as anything can get in America. Well, maybe not quite. All you have to do is look at more than 30,000 pages of the Internal Revenue Service Code, the gobbledygook that no two IRS agents can agree on, to know how the government conspires to defeat you legally on every front. It's the ka-ching, ka-ching factor. There are 190 United States colleges and universities that graduate more than 30,000 lawyers each and every year. The legal system must continue to be expanded and become more complicated to assure that these hordes of lawyers have meaningful employment. Japan has half the population of the United States, and the entire nation has less than 100,000 lawyers. The United States has 1,800,000 lawyers and more graduating every year. And they all have to eat, they have to buy homes, they have to drive nice cars, and if they're in the criminal side as a defending lawyer, they don't make nearly as much money as a civil lawyer, but they have a lot more fun doing it. And we've all seen the lawyer shows on TV and how criminal lawyers work their clients in the system. All very entertaining, but less based on the real world than a 1-hour venue which opens and closes every case. Those shows compress into 1 hour what often takes years to bring to any sort of conclusion, even with a guilty plea and upfront. So during the time your lawyer is working your case, it seems like he's working it every day and every minute on your behalf. You only represent billable hours to your lawyer, the ka-ching, ka-ching factor. Your lawyer will smile. He will act like he's worrying about you. He'll exude confidence in his ability to defend you, and he will lull you into believing that he is your salvation, that he will win a dismissal, an acquittal, and an aggressive defense that no one else will be able to do. Win, lose, or mistrial, your lawyer will always get paid in advance. Lawyers are the only profession that receives payment with no recourse if you do not receive a favorable result. A doctor can be sued for malpractice. A mechanic's lien on your property can be removed and the contractor sued for faulty workmanship. But your lawyer is virtually immune from the liability due to malfeasance or incompetence, thanks to the laws that they designed themselves and their relationship with their judges, who always rule in their favor. It's the ka-ching, ka-ching factor. You will pay a retainer in advance and receive itemized statements on a not-so-regular basis. As the retainer depletes, your lawyer will ask you for more money in advance. You will be astonished at the line item billings. Some will be indecipherable and will be explained with guile and conviction. You will easily get the impression that you must be the only client that this attorney has, because every single waking hour seems to be working on your case. Anyway, the final argument is, well, you can always file a 2255 remedy for ineffective counsel, which means incompetent representation. But you can never do that in front, only after you've been convicted and you're whiling away in prison. And virtually every prisoner I ever met in prison was filing a 2255 against incompetent representation, saying they didn't get a fair shake. Well, none of them ever got a new trial as a result of that, the ka-ching factor. And I'm not going to talk about that anymore. Okay, so I'm going to talk a little about if you're wrangling your way through the legal process. Here's what's going to happen. It's called the injustice system. In order to defend yourself from the allegations made by the federal government, you may have to sell or mortgage your house and stocks and bonds and your wife's jewelry and whatever else. It depends on whether the government has seized your assets and or whether they can use them at all. And the ordeal can be long and tenuous. It will affect you, your family, and your precarious financial situation, especially if you're not able to continue to work out on bond. Okay, the United States government has unlimited time and resources with which to mount a case against you. They have the manpower and database to investigate every aspect of your life. The government can trace you virtually back to your day of birth. They can and will interview many witnesses and use every ploy and trick in an attempt to groom informant or snitches to testify against you. A witness brings much more to the party than physical evidence. And all the while, you're paying your attorney to review every piece of paper brought to him through the discovery and his own effort on your behalf. The cost will mount dramatically as time goes on. If your resources are such that you do not have the wherewithal to pay for legal services, you will be given a federal public defender to represent your interests in court. The public defender won't cost you anything, but you get exactly what you pay for. The public defender, aka public pretender, their plate is full. Not one of them has less than 300 or 400 or 500 clients they have to deal with, because most people that end up being arrested, vast majority of them have no money, but they are guaranteed legal representation. Your public defender does not want you to go to trial. You will be tying up the courts and preventing him from processing his other 300 or 400 clients in a timely manner. So what he's going to do is make every effort to convince you and the prosecutor to cut such a deal that you will accept a guilty plea on lesser charges, so you will go to jail and process yourself through the system more quickly. Hear this and hear it well. If you do go to trial, if you decide that the case against you has no merit or has a little chance of being winning a conviction for the prosecutor, if you do lose, your sentence will likely be twice as it would be if you just entered a guilty plea, because the courts are very upset with you, particularly the lifetime sitting judges who want to process you like putting tomatoes in cans, and you're tying up the ability in a 2-week courtroom to process 200 or 300 other people through the system nicely, so that they can impose their fines, impose their sentences, chalk another notch on their gun belt, and go on to their next party bragging about how many people they put away for how many years today. Okay, you have rights after you've been arrested. I'm not going to get into that. You can get bail in the beginning sometimes, depending on the notoriety of your crime, whether you're a flight risk. I'll get into that another time. Judges and judges as lawyers, my favorite topic. Judges have the power, virtually unlimited power, to set sentences and penalties for any accused brought them and found guilty. Federal judges are appointed by the president for a lifetime position. Totally outrageous. I know it's in the Constitution. If there's anything that has to be removed from the Constitution, it's the fact that Supreme Court justices and federal judges sit a lifetime on the bench. They act as demigods, and they begin to think they're demigods. They are unchallenged. They run that courtroom with an iron fist, and how dare you question them and their ability and their position. They are omnipotent in their position and are rarely removed. Most aspire to being a circuit court judge or even a Supreme Court judge. Federal judges tend to become tainted with the constant flow of accused felons that come before them. Remember, the federal government, that means the assistant U.S. attorneys and the prosecutors, have a 97% conviction rate because they stack charges and demand a guilty plea for reduced fines or sentences. Judges, in the back of their minds, sincerely believe that all that come before them are accused are guilty of that crime. Americans do not live under constitutional law any longer. The courts regularly give lip service to the renderings about the Bill of Rights and your rights under the Constitution. In actuality, the courts treat the Bill of Rights as if they were a privilege to be doled out, or granting a reneging of these privileges by the court or the prosecutor. The Criminal Code Title 18 claims that federally imposed guidelines are required to be used as a standard by judges in ruling when in fact they are merely subterfuge to make you believe that the judges are constrained by these guidelines. Judges consistently use the guidelines, which are nothing more than another name for mandatory sentencing requirements, overturned by Booker versus the United States in the late 2005. The government simply changed the heading, added an downward departure clause, and then simply republished it. Okay, and we're back to the high priest. As rare as this, the high priest sits on a bench, an elevated platform with a gavel and flags behind him, assuring you that he represents the government and the people of the United States in every rendering. He wears a black robe like a high priest in the courtroom and has the decorum like a sanctified church, walnut, quiet walls with mahogany or oak, and a near subservient demeanor and a humbling whisper that goes about the courtroom, all but bowing before this high priest. No one dare disrespect this high priest, or he will reprimand any and all who do, with certain deference to the prosecutor. After all, these two are in collusion and like-mindedness as far as all accused before them. The judge will find any and all who he perceives as contempt for the court, which is himself, and will even send them to jail indefinitely if he perceives that the contempt was egregious enough, and that might just be a sneer. While the judge is to be the arbiter between the prosecuting and defending parties, he often acts as attorney from the bench, which is totally illegal and unethical. It happened to me, and I'll tell you about it in a minute. And how does he do this? By offering advice and suggesting tactics or remedies, or other charges that might be brought by the prosecutor in the courtroom venue. He, by law and ethics, is prohibited from doing this, but the federal judges regularly do this, and they practice law from the bench, and no one dare challenge this. And here's what he did for me. While I'm going through the sentencing phase of my process, the judge, in his infinite wisdom, for reasons that are still unknown to me, rather than a 30-minute sentencing courtroom period, allowed a 3-hour question and answer session with the Federal Bureau of Investigation, the agents who arrested me, and he read me the riot act about my activities in Idaho and said, but it didn't have anything to do with the sentence that he imposed on me. Then he suggested to the prosecutor, while I'm on the stand, and my attorney never objected to any of this, that they could have filed 3 additional charges against me, and the prosecutor said no, they weren't going to do it. Well, that sounded pretty good to me, but the idea and notion that the judge would do that from the bench went beyond the pale. But these guys act with impunity and immunity. They can say and do anything they want. Well, I found out later that any charge can be brought within 7 years if a prosecutor decides not to prosecute. Well, my 7 years is almost up. So I have a feeling, because of my activities and how the court hates me and my activities in the internet and my spewings and my writings and my mailings and my past performance in giving lectures and speeches at various congresses, that they're going to bring those charges against me next year or within 6 months. So look for Vincent Bertolini to be back in prison as a result of these spurious and evil and capricious, pernicious judges and prosecutors. They wouldn't dare do it because then they could run the sentences concurrently rather than consecutively, but they're letting this one run out, get me through my probation, and then file new charges against me on the issues that they could have taken then. That's that's called selective prosecution, by the way. Again, almost illegal and certainly unethical. That's my say about it. Okay, so here's the deal. No one challenges the judge. Why? The judge nearly always makes his comments to the prosecutor, who is glad to have more ammunition with which to bring about a conviction and a longer sentence. The defense attorney is afraid to affect his standing with the court. Never forget, the attorney's first obligation is to the United States government. His second obligation is to the court. His last and final obligation is to you, his employer, whom he is defending for your freedom. You are his last consideration, and he will never jeopardize his standing in the court over you or anyone else. He too must lick the boot of the high priest judge, who can and will oppose the harshest sentence that he can get away with. No sitting judge wants his rulings overturned on appeal, even though the judge profession is the good old boys club, and they usually look out for one another. They do want to follow a semblance of the letter of the law when proceedings are being conducted, and when your due process is being carried out, and when they impose sentences. Okay, so, I mean, what can you say? What can you say? Sentencing and the guidelines. Well, I'm going to talk about plea offers. I was going to do that. No point in that. Talk about the entire prison system, the detention system, how to work your way through it. There are guys that get $40,000 from rich people who have been arrested, indicted, look like they're going to be convicted, and these consultants go in and sit with them and the family, and have even written books that they charge exorbitant amounts for. And up to $40,000, as I said, to shepherd them, yeoman them through the legal process and what to expect inside, how to conduct yourself inside, all that. I put a book together. It took me 4 months to write it after I had taken 4 years of notes. It's right here. I only wanted $20. I can't get anybody to buy it. And guys are getting $40,000. I don't know what to say. Anyway, I'm going to move into part 3. It's going to be a little disjointed. Part 3 is recidivism, and why we convicted felons end up back in prison 70% of the time. You don't believe that? Well, it looks like we're unrehabilitated. They can't rehabilitate us, and we're just criminals. And that's why we go back to prison. No, dear ladies and gentlemen, you go back to prison because you have so much more imposed upon you than John Q. Citizen or Joe Sixpack that it's almost inevitable you go back to the entire system is geared against you. Once you have come under the federal government scrutiny, the party is over. Your life changes forever. You see these movies on television where the narcs or the snitches, particularly with the mafia or mob, when they bring down a big kingpin, mobster, capo, de tutti capi, a don, they get in the witness protection program and they end up working menial jobs. It doesn't matter. It doesn't matter whether you're a convicted felon or whether you narc on somebody. You get these menial jobs. Nobody will touch you with a 10-foot pole. It doesn't matter whether you committed a crime that was murder or whether you had a victimless crime where you got caught smoking a joint or carrying a sawed-off shotgun in your car. Yeah, they look at you just the same. You're a convicted felon. They don't care whether it's a first degree, third degree, fourth degree, or fifth degree felon. Class A, B, C, D. It doesn't matter. The public at large has been brainwashed by all these television shows. The United States government, the most treasonous government that the America has ever seen since 1960. Nobody blinks. Nobody blinks. Well, they all get what they deserve, and I'm not done with the government yet. That's probably why I'm going to end up in Florence in the cellar in the Supermax, because I'm just beginning to go on my rhetoric. Okay, I'm done. Go to part 3 if you want to learn about recidivism. Bye. Oh, I shut this thing off. Okay.